What are your rights if accused of shoplifting in New Jersey? Facing a shoplifting accusation in New Jersey can be frightening, but knowing your legal rights can help you handle the situation wisely. Under New Jersey law, shoplifting is defined in NJSA 2C 20-11 as intentionally taking or concealing merchandise without paying full retail value, and it includes activities such as altering price tags or underringing items. The state must prove that you consciously intended to take the merchandise without paying. Accidentally forgetting to scan an item is not enough. If store security or police accuse you of shoplifting, your first right is to remain silent under the Fifth Amendment. You are not required to explain yourself, sign documents, or answer questions, because anything you say can be used against you. Your second core right is to have an attorney represent you. If the court finds you cannot afford a lawyer, you may qualify for representation from a public defender, but many people choose a skilled private lawyer to devote more time to their defense. You are presumed innocent until the state proves each element of the shoplifting charge beyond a reasonable doubt. Store security may detain you briefly if they have probable cause, but they cannot use excessive force or hold you for an unreasonable time, and police must follow lawful arrest procedures including reading your Miranda rights. You have the right to refuse consent to a search and to decline to sign incident reports or admission forms without your attorney present. Do not offer to pay for the item because doing so can be taken as an admission of guilt. Provide only basic identification such as your name and address and do not volunteer details about what happened. Never attempt to flee from store security or police, because running may be taken as consciousness of guilt. Shoplifting charges in New Jersey vary based on the value of the merchandise and can range from disorderly persons offenses to second-degree crimes. If the merchandise value is under $200, the charge is a disorderly persons offense handled in municipal court, punishable by up to 6 months in jail, fines up to $1,000, and mandatory community service. When the value is between $200 and $500, it is a fourth-degree crime prosecuted in Superior Court with potential penalties of up to 18 months in state prison and fines up to $10,000. Items valued between $500 and $75,000 constitute a third-degree crime carrying 3 to 5 years in prison and fines up to $15,000, and amounts over $75,000 associated with organized retail theft elevate the charge to a second-degree crime with 5 to 10 years in prison and fines up to $150,000. Shoplifting complaints can take weeks to months to result in a summons because the timeline depends on when the complaint is filed and how quickly prosecutors process the case. You may receive the summons by mail or be asked to report to the police station, and charges can be filed even if store security releases you at the scene. The statute of limitations is 1 year for disorderly persons offenses and 5 years for indictable offenses. If store security confronts you, stay calm, listen carefully, refuse to sign documents, do not pay for the item, provide only identification, cooperate physically while remaining silent, and contact a defense counsel as soon as possible. Legal representation can help challenge the state's evidence, negotiate with prosecutors, and secure dismissals or diversionary programs, especially for first-time offenders. An experienced criminal defense advocate can defend you at every level, whether your charge is a minor offense or an indictable crime. If you are facing a shoplifting accusation, you should immediately seek legal counsel to protect your rights and mitigate potential penalties. Lustberg Law Offices, LLC at 1 University Plaza Drive No. 212, Hackensack, New Jersey, 07601, United States, is a law firm offering dedicated representation and can be reached at 201-880-5311. Contact the law firm today to schedule a consultation and safeguard your future.